Good afternoon, everyone. Welcome to CommonCL Carey's webinar on addressing employee complaints, retaliation, and whistleblower claims. So before we jump into our substantive presentation, let's take a couple minutes to all introduce ourselves, and Jordan will start us off.
Thank you very much, Lindsay. I'm glad to be here and presenting to you all. My name is Jordan Schwartz. I've been a partner here at CommonCL since we started in, I believe, 2014. So we're getting close to 10 years here. Unlike Lindsay and Victoria, who do both employment law and OSHA, I focus primarily on employment law. However, I also, since I do so many position statements in the employment law context and in the retaliation context, I also do my fair share of OSHA responses, 11C responses, for those of you who know what that is. If you don't, we will be telling you what that is, and what the employer responds to in response to an OSHA related safety complaint. Other than that, I do general employment litigation on every single employment law issue that arises in the workplace context. And I also advise employers on policies and procedures. And we'll talk about some of those today, such as employee handbooks and various policies that you should have in place to be able to respond to different types of position statements. And finally, I also inspect workplaces to make sure they're compliant from an ADA perspective under the Americans with Disabilities Act.
All right, and the voice you're hearing now is mine, Lindsay DeSalvo. I am a partner at CommonCL Carey in both the firm's OSHA practice and our employment practices. I feel like a lot of my practice in the last couple of years has involved addressing retaliation and whistleblower complaints. There's definitely an increase that we have seen on our end for our clients of, additional or more complaints being filed with outside agencies. But similar to Jordan, I also advise employers on the policies and practices that you can have in place to hopefully encourage employees to make some of those complaints internally and be investigated internally and handled internally. Whether that is a complaint process, which we'll talk a little bit about today, or assisting with the types of training that we advise employees receive to ensure they know what that process is, as well as representing employers in inspections and investigations, and enforcement and litigation that can arise from potentially whistleblower complaints, but also OSHA citations or investigations and enforcement actions from outside agencies. And I will let Victoria close out our introductions.
Hi, I'm Victoria Voigt, and I am of counsel with CommonCL Carey. I do OSHA work. I also do employment litigation work. I come from the public sector. So I represented the state of North Carolina in proceedings for a very long time. And I think I bring that perspective, the state plan perspective, the public employer perspective to some of the discussions that we have here. And I think that's it for me.
All right, well, then we will get into our agenda for the webinar today. So we have 4 main areas that we are going to try to cover in the time that we have. The first is sort of providing some context for this issue and reviewing the major anti-retaliation and whistleblower protections that are in place, generally from a federal perspective for this presentation. Then we'll review the types of charges that can be filed, timelines for those charges, and burdens of proof that the outside agencies will have to evaluate the complaints against. Then we'll spend a little time going over strategies and techniques for responding to retaliation complaints. That's generally going to be in the form of position statements. So we'll talk about, what those are, what we like to provide information-wise in our responses to the complaints filed by employees. And then finally, we'll close out with some recommendations for how to avoid these types of complaints being filed. You know, as I mentioned in my intro slide, a big part of this too is how can you avoid employee complaints being filed outside of your facility or outside of you as the employer. You know, we'd rather these complaints be filed internally and responded to internally. So we will go over some techniques and things that we advise our clients to do to try to ensure that complaints are made internally and can be handled internally. So our first section, the major anti-retaliation and whistleblower protections. So OSHA's whistleblower role is actually pretty significant. OSHA is in charge of investigating complaints under Section 11C of the OSH Act. And as you'll see in some of the data we'll review in just a few slides, Section 11C whistleblower complaints are the biggest type of complaints that OSHA is responsible for investigating. But interestingly, OSHA is actually charged with investigating 22 different statutes. So different statutes such as environmental laws, Sarbanes-Oxley Act, the Affordable Care Act, they all have their own whistleblower provisions or anti-retaliation provisions. And OSHA is actually responsible for investigating, you know, in having those complaints filed with them, investigating those complaints, and then ultimately making a determination as to how to proceed with those complaints. And so the burden on OSHA is pretty high, and we've seen in the past couple of years, particularly as the number of retaliation cases has increased, that OSHA's focus on this issue has also increased. This is the whistleblower investigations and whistleblower claims have definitely become a more significant priority for OSHA. And we've seen in the past couple of years that they have focused more resources as well as personnel on these investigations. They hired quite a few additional investigators back in 2022, I believe, early 2022. And I think that trend will just continue as, you know, the priority and focus continues on the whistleblower role. And that is particularly significant in the context of OSHA, again, because they do have all of these laws that they're responsible for investigating when complaints are filed. So we're going to focus specifically on Section 11C of the OSH Act, mostly in our discussion around sort of the OSHA side of investigating whistleblower complaints. And that, again, is because most of the whistleblower complaints that OSHA receives are those that are filed under Section 11C of the OSH Act. So similar, you know, for those of you sort of more familiar with the employment side and anti-retaliation provisions, the prohibition in the OSH Act is very similar to what you will see in things like Title VII. And that is no person shall discharge or in any manner discriminate against any employee because such employee has filed any complaint or instituted or caused to be instituted any proceeding under or related to this chapter. And then you'll see the rest of the text there. So again, under the OSH Act, you know, the OSH Act is very safety focused, and the regulations that are promulgated per the OSH Act, employees that are exercising their rights under the Act, as well as those regulations, are protected from being retaliated against or discriminated against because of the activities that they undertake that are protected by that law. We will also be focusing today on the EEOC side and the laws that the EEOC enforces, the anti-retaliation provisions specifically that the EEOC enforces. And these are sort of the main laws that the EEOC is charged with enforcing, and also the main laws under which we see anti-retaliation or retaliation complaints being filed. I think probably the most significant of these laws under which retaliation complaints are filed is Title VII, but all of these laws have their own anti-retaliation provisions. And we'll often see at this point that, you know, a charge of discrimination under any of these laws will also sort of go hand in hand with a charge of retaliation. And we'll see some statistics on that, but over half of the complaints that are filed with the EEOC do contain some form of retaliation allegation. And like I said, Title VII is really where we see the most activity as far as retaliation complaints being filed by employees or former employees. And the language is very similar to the OSH Act in the sense of employers are prohibited from retaliating against an employee who basically exercises their rights under the law. And that's pretty broad under the OSH Act. It's also pretty broad under Title VII. And the language you see that we highlighted there, because the employee opposed any practice made unlawful by this subchapter, or because they made a charge, testified, assisted, or participated in any manner in an investigation. So again, a really broad understanding of the types of activities that can be protected under the law. And it's, it's really sort of if an employee is attempting to exercise their rights or exercise rights on behalf of other employees under that law, then they have protection from retaliation. So the next few slides are just going to show some statistics that we think are helpful in sort of setting the stage for why this issue is so important right now. So the first slide here is the prevalence of whistleblower complaints. And this is specifically for whistleblower complaints that are enforced and investigated by OSHA. You'll see highlighted there that, again, the majority of complaints that are being filed with OSHA are being filed under Section 11C of the OSH Act, and that's about 76% of the complaints that are filed with OSHA are filed under Section 11C of the OSH Act. And as I previously stated, OSHA takes a really broad view of the types of activities that are protected under the OSH Act. So it could be anything from an internal safety complaint made to the employer and the employee asserts that they were terminated because they made those complaints, to actually, filing a complaint with OSHA or participating in an OSHA investigation. It's really broad. So in fiscal year 2022, there were about 2,148 complaints filed under Section 11C, and you'll see that is actually quite a significant increase from fiscal year 2021. I think that's around 257 additional complaints that were filed under Section 11C. So again, the whistleblower complaints are not only a priority for OSHA, but we've seen in the past few years, particularly since the pandemic, that employees also have sort of a broader and better understanding of their rights under Title VII and their rights under Section 11C of the OSH Act. And so we're seeing a continual increase in the amount of complaints filed. Interestingly, fiscal year 2020 is right in the midst of the pandemic. You'll see that there was the largest amount of Section 11C complaints filed, which makes sense, in the context of COVID. There were a lot of allegations related to safety surrounding how employers were handling the COVID-19 pandemic. So I think that's the reason that particular year is so high. But outside of that, you'll see that there has been a pretty continuous increase in the number of complaints filed under Section 11C. It is also, I think, important to note that there is a relatively high dismissal rate of whistleblower claims. Again, sort of the resources that OSHA has been able to focus on whistleblower claims and complaints in the past, I think there hasn't been as great of resources. I think it's also, they're stretched thin with the various statutes that they have to investigate and enforce. But I think it is also important to note that approximately 28% of all 11C complaints do result in a positive outcome for the complainant. So that's over a quarter of cases that might result in a settlement or a merit finding. You'll see that most of those positive outcomes based on this data are settlements. So, it is still, I think, really important to sort of put your best foot forward in responding to these. You also see that a lot of them are dismissed, and that can happen because an employee doesn't meet the requirements for filing the complaint. But in our experience, a lot of times that happens because, the employer can show that there's no causal connection between the protected activity and any adverse employment action that occurs. So, in going through this presentation and sort of strategy for responding, it's really important to put your best foot forward in the response to hopefully, again, get it dismissed or even, potentially motivate the employee to withdraw the complaint if they see that it's likely not going to be successful. And then finally, this last slide here shows some data on retaliation complaints filed with the EEOC. You'll see that in fiscal year 2021, around 56%, so over half of the complaints that were filed with the EEOC had retaliation allegations as part of those complaints. And then again, under Title VII, the complaints that were filed under Title VII, around 41% of those complaints had a retaliation claim in them. So again, this is just sort of to reinforce the idea that retaliation is a big issue. It is something that has definitely been a focus of employees and the complaints that they are filing with outside agencies. And so the importance of sort of understanding the burdens of proof here and strategies for response are really important. And with that, I will turn it over to Victoria.
Great, thank you. So next up, we are going to be talking about reviewing charges and burdens of proof. One thing that is important to consider when you are looking at whistleblower complaints is the fact that there are specific timeframes for the employees to file these complaints. If you look at the current slide, you'll see that for OSHA, it is 30 days for filing a retaliation complaint. And that's the first day of the time period after the alleged retaliatory decision is made and communicated to the complainant. So we can get into discussions of that down the road when you're talking about the elements of a claim and defending a claim, but it is really important to know those timeframes. The complaint process is really informal. So complaints can be filed electronically, they can be delivered through other means, they can be done orally, they can be referred from other DOL partners. The investigation process is very similar to an investigation process for an EEOC charge, if you're familiar with that process. The investigator will review the documentary evidence presented by the two parties. They may or may not interview parties. They may request additional information. Unlike EEOC, there is no private cause of action under 11C. So OSHA is required to bring the lawsuit in district court on the employee's behalf, assuming that it finds merit. Or attempt to settle the matter informally. Now, there is actually a statutory provision that says that OSHA should issue its determination within 90 days, but that's directory. It means that they don't necessarily have to comply with it, and there is no penalty for not complying with it. I think really the most significant difference between 11C and EEOC charges is the lack of a private right of action. The only thing that a whistleblower can do if OSHA decides not to find merit or not to bring a lawsuit is to file their own complaint with OSHA about OSHA's activities. I will note, we're talking about the federal laws at this point, but in states with OSHA approved state plans, the employee can file either with the state plan or with FedOSH or both. And in those states that have those kinds of statutes, and North Carolina is one of them, the timeframes for filing can be different. And also there can be a private right of action. And in North Carolina, there is. All right, under EEOC, the time frame is much broader. It's 180 days from the day the Retaliatory Act took place. It can be longer if there is a state or local law that prohibits discrimination on the same basis. There's no specific time constraint on determinations of the charge, and they can take a very long time. If after 180 days, the employee has not received some kind of determination from EEOC, they can request a right to sue letter and go to court. If they do that, they need to file in court within 90 days. Okay, so there is a new whistleblower investigations manual that became effective in 2022. Per the manual, the current standard for evaluating complaints is whether there's reasonable cause to believe that retaliation occurred. The evidence gathered during the investigation is what they will base that determination on. They will require evidence supporting each element of the violation, but the burden for finding cause, as opposed to winning in court, the burden for finding cause is lower. In 2016, prior to 2016, a complainant actually had to establish a prima facie case of retaliation on each element. This reasonable cause requirement is lower. All right, so the provision for that means that it is easier to get a cause determination than it used to be. When investigating a charge, EEOC assesses whether there's reasonable cause to believe discrimination occurred. So again, we're talking about reasonable cause. And it does the same thing. It reviews the facts and the evidence presented by the charging party and the employer during the course of the investigation. The employer provides a position statement that should address each allegation in the charge. It may or may not do an on-site visit, witness interviews, or request additional documentation. The message here is the more thorough the response in the position statement, the less likely that EEOC is to request on-site visits, witness interviews, or additional documents. Also, the more thorough the response to the charge, the more likely it is EEOC will issue a no cause determination. The takeaway is to provide all the information needed up front so that they don't come back asking for more. All right, the elements of an 11C whistleblower claim: you must establish that the employee engaged in an activity protected by a specific statute. The decision maker must have knowledge of the protected activity. The complainant must demonstrate that they suffered some form of adverse action, and that the employer would not have carried out the adverse action but for the protected activity. In the context of an EEOC anti-retaliation claim, knowledge is a component of a causal connection. In a whistleblower claim, it is an actual element. So what is a protective activity? In 11C, it's making a workplace safety complaint to OSHA, or participating in an OSHA inspection, or complaining to the employer of workplace safety issues, or participating in an OSHA enforcement proceeding, which would include testifying. In some cases, it can include refusing to perform a dangerous task assigned. Now, what are those circumstances? What they're looking for there is whether or not the employee made a reasonable effort to bring to someone's attention, particularly the employer, the concern about the dangerous task before they refuse to perform it. Right? In order for someone to retaliate, they have to know that you did something first. So here, Employer knowledge is always an element. The decision maker must be shown to have knowledge of the action before the adverse action is taken. So I have to know that the employee complained to OSHA in order for me to retaliate against the employee by giving them a disciplinary action or firing them or demoting them. Now, generally, knowledge means actual knowledge, but there are certain circumstances where they will impute knowledge to the employer. An example would be if the complaint is about a unique piece of equipment, and this employee is the only one that operates that equipment. It's kind of you had to know who it was that filed the complaint. There may be similar circumstances for small employers where it seems like everybody knows everybody else's business. And so it's pretty easy to assume who filed that complaint. What is an adverse action? It has to be both materially adverse and adverse in the view of a reasonable employee or applicant. So that's the objective standard. Adverse action doesn't necessarily need to be related to employment, and that might be something like a reference, but generally it is. So if it's materially adverse, we can say, definitely if you're fired, that's materially adverse. If you are demoted, that's materially adverse. What if you get a written warning? Is that materially adverse? Well, it depends. If that written warning might prevent you from applying for a transfer or applying for a promotion, then that might be considered materially adverse. So what kinds of actions are considered adverse actions? We've got the list on the left, which are all the ones that we would think of. You got discharged, you got demoted, you didn't get hired, you didn't get promoted, you didn't get your bonus, somebody changes your duties or changes your benefits. But the ones you might not think about, and some of the slippery ones are on the other side in the OSHA guidance. Blacklisting, you gave them a bad reference. Harassment is always in the eye of the beholder. Hostile work environment is in the eye of the beholder, as is making a threat or intimidation. Those are, the employee may see the thing that was said, thing that was done as an adverse action. But these items on this side are really going to take some fleshing out to understand whether or not they are in fact adverse actions. So what's a causal connection? An employee must show but for the protected activity, the adverse employment action would not have occurred. Okay, so there has to be a sequence here. I engaged in an adverse activity, and then, I engaged in some activity and then protected activity, and then something bad happened to me. Now, if the something bad happened to me first, then we can't have a causal connection. Now, say I engaged in a protected activity and then something adverse happens to me. Well, one of the things they're going to look at on that is times. What is the time frame? So we are really looking at the agency level, is it reasonable that we have a causal connection here? Does the sequence of events seem to suggest that there is reasonable cause to believe that but for this protected activity, this employee would not have suffered this adverse action? All right, if the time period between the protected activity and the adverse action is relatively short, they're going to think it's more probable than not that this is a but-for situation. The longer the time between the protected activity and the adverse action, the less likely it is to assume that there's a causal connection. So in this case, the Supreme Court has said that with a 3 to 4 month period is stretching it a bit far to believe that there's a link here. In looking at any kind of a case, you are looking for whether or not there was a legitimate non-discriminatory reason for the adverse action. So even if you show that the employee engaged in a protected activity, and if something adverse happened to them shortly after that, still we have to look and see if there was a legitimate reason for the adverse action. And the employer simply has a burden of production on here. The burden of proof always remains with the employee. So if the employee engaged in a protected activity and they were later fired, but the reason they were fired was because they were insubordinate and it had nothing to do with refusing to do what they considered to be a dangerous job, or if they had absences or poor performance that had been thoroughly documented, because that's a particular area that you're going to want to make sure you have good documentation on that poor performance, or if the employer is doing a layoff because of financial hardship, or if there is some violation of an employer's policy, which would include their safety policies. Those are all legitimate non-discriminatory reasons for taking that adverse action, and they would have to be considered in determining whether or not retaliation occurred.
Thanks, Victoria. Before we jump into the next section of the more practical section of the webinar, and actually sort of discussing techniques and strategies for responding to complaints and proactive measures that you can take, we thought we'd try to respond to some of the questions that have come up during this first section of the webinar. And then we can hop into that piece. And I'll ask my colleagues to jump into on responding to these. But the first question we see is, do you think that the pandemic is the reason for the increase in whistleblower complaints in the last couple of years? Yes, I do. I think we would all agree that the pandemic certainly brought to light, I think, for employees and the population at large, some of these laws and anti-retaliation protections that were in place for a long period of time that just weren't maybe as well known and understood. Certainly we saw from that data in 2020 and the amount of 11C complaints that were filed, and that was sort of the highest number that we've seen in at least the last 5 to 6 years, probably longer. I think that really sort of supports this idea that, employees became more aware of these anti-retaliation provisions, how they could proceed with filing these complaints, and certainly took advantage of those protections during the pandemic more than we had seen in the past. And I think, that knowledge continues to be present today. So certainly, again, as we see an increase in these anti-retaliation complaints, both filed with OSHA and filed with the EEOC, because there were provisions of Title VII that were certainly significant issues during the pandemic related to protections based on religion and disability. That knowledge is there and certainly continues to be a part of why we continue to see these increases, as well as I think the greater focus that OSHA as well as the EEOC has had on these whistleblower and anti-retaliation complaints, and efforts to sort of educate employers and employees about these provisions.
Yeah, and I'll just jump in there and basically echo what Lindsay said, which was a terrific answer. And just starting in March 2020, soon thereafter, these we saw the uptick in these charges, and yeah, it's no surprise that the focus from employee standpoints is my employer doing enough to keep me safe? And if not, if I complain about it, will some sort of adverse action occur to me? And just thinking about it kind of from a common sense perspective, you can kind of see how an employee might think, why these charges increased, because any employee who did get terminated or demoted or whatever the case might be might think it was because they raised some sort of issue, because all sorts of employees were raising safety related concerns during that time to make sure that they were treated in as safe a manner as possible. And similarly, like Lindsay said about especially with vaccine mandates and things of that nature, retaliation claims under Title VII of the Civil Rights Act or under the ADA just became so much more prevalent, because I don't even know if that many employees knew before that they could raise those issues. And again, if an adverse action happened, then they could rely on those laws to assert some sort of retaliation claim.
Yeah, and just to add a little bit more, I mean, I think I saw the second part of this question was, there were 2,000 complaints filed. That number seems rather low on, a nationwide level. What do we attribute that to? I think it certainly is the case that considering the amount of employers and employees out there, that a majority of employees are not necessarily filing these types of complaints. But I think, the important takeaway from that section of the presentation is just that this does continue to be a significant issue. And certainly some of the reason, that these complaints might not be filed with the agencies sometimes, and hopefully this is the case, in a lot of instances, that there is a process in place with the employer to file those complaints and have them addressed in a manner that sort of satisfies the employee, and they don't necessarily need to go outside to the various agencies to file these types of complaints. Another question that we saw is, if an employee opposes an employment practice because they have a good faith but incorrect belief it is unlawful, is that opposition protected under the whistleblower provisions of Title VII? And that's a really good question. And the general answer is yes. If an employee has a good faith belief that something is protected by Title VII, that an employer acted in a discriminatory manner toward them or others, and exercises their right to complain or exercises their right to go to the EEOC based on that, even if that is ultimately wrong, that discrimination claim might go away because there isn't actually a basis for discrimination, but the retaliation piece is sort of treated differently and a little separately from that. And the retaliation piece could still proceed if it meets the elements that Victoria just discussed.
Yeah, and just to put that a different way, you as an employer, are not permitted to now take an adverse action against this employee because he was incorrect. He said, you treated me unfairly under Title VII, and it turns out that his complaint isn't covered by Title VII. That doesn't mean you can then treat him unfairly if he still believed that you did, that his complaint was protected under that law. So you would still treat the person the exact same way, as Lindsay said, regardless of whether or not they were covered by the law.
And we'll do just a couple more to make sure that we do have time to go through the practical side of this webinar as well. I do see that there are more questions coming in, though, and we'll certainly, toward the end of the presentation, also have some time to address additional ones. We'll do just a couple more now. The next one we saw is the reasonable cause standard the same as preponderance of the evidence standard? The reasonable cause standard is a little bit, it's a lower burden than the preponderance of the evidence standard. And that's the idea there. And I think, Victoria talked about this a little bit in her section of the presentation, is that, at the administrative agency stage where they're sort of just evaluating whether it's reasonable that an employee could support with evidence the prima facie factors of these complaints, that burden is going to be a little bit lower than when you go to an actual administrative hearing or a trial where an employee would actually have to show by a preponderance of the evidence that they meet their prima facie case, to be successful ultimately on that complaint. And then we'll do just one more here. So the question is, so the other adverse actions under OSHA are not considered adverse actions under the EEOC, such as blacklisting. EEOC does not consider that an adverse action. Both of these laws and any potential adverse actions under these laws will be sort of a case-specific consideration. That both the EEOC and OSHA would look at the impact of the employment decision and whether it is materially adverse, as Victoria referenced. We included those examples in that slide because OSHA very explicitly and specifically in its whistleblower manual lays out the activities that are protected under Section 11C of the OSH Act and what could be considered an adverse employment action related to 11C, as well as the other whistleblower provisions that it enforces. But that's not to say that something listed there isn't necessarily something that would be considered an adverse employment action in the context of a Title VII claim filed with the EEOC. It would just be a really specific analysis of the facts surrounding that and whether it meets that standard that Victoria discussed in her section of the presentation.
Basically a judge, or let's say the EEOC, and then if a lawsuit is brought, a judge is determining, is blacklisting, does that have an adverse effect on the individual's employment? And there, again, although it's not specifically laid out like it is in OSHA, there's a good chance a judge would say, yes, that is detrimental to the individual's current employment or future employment. So it would be considered an adverse action. The EEOC doesn't have some magic definition. It's really kind of a common sense approach. Typically you're dealing with termination. That's pretty darn easy. It gets much trickier when you're dealing with something like blacklisting or say something like, you transfer someone from one facility to another facility and it's a further commute and it might be, less desirable hours at that facility, or, the atmosphere isn't as conducive to, what this employee likes. Is that adverse? It can really get as Lindsay said, very factual specific. But we didn't mean to say that, it's necessarily a lower burden under EEOC than OSHA. At least that's my understanding.
Lindsay?
Yep.
Yeah. Can I take one of these questions before you move on?
Sure.
Okay. So the question here is, can you define burden of production and what is a private cause of action? Burden of production is just coming forward with some facially reasonable explanation for what you did. So it is simply the employer saying, I know they think this is the reason, but here's my evidence, whatever that evidence is, as to why we did what we did. And it's not retaliation, it is this other thing. So you just have to come forward with a reasonable explanation of why you did what you did. And that's really the burden of production. What is a private cause of action? A private cause of action would exist under EEOC when they give the employee a right to sue letter, and the employee can then, in their own name, bring a cause of action or in state or federal court against the employer. So that exists on the EEOC side, and it exists in some state plans, but it doesn't exist on the OSHA side. On the OSHA side, only OSHA can bring an 11C action against an employer. On the EEOC side, EEOC can bring an action against the employer, or it can issue a right to sue letter and the employee can bring their own action in state or federal court. And that's called a private cause of action.
Great. Thanks, Victoria. I'm gonna jump in now and get to these last two sections. And then if there are new questions that come in or other questions that we haven't gotten to, we will do our best to get to those questions. But we do want to make sure to cover the material. So in terms of responding to the whistleblower complaints, it is very important to have some sort of process in place so that your company knows, how a complaint should be managed, regardless if it's a complaint from the EEOC or from the Department of Labor, or, which promulgates the OSHA complaints. And the first part of this process seems intuitive, but we've actually, represented clients that have struggled in this first part of the process. And that is, you need some sort of system in place to ensure that anyone who might receive the complaint knows who to direct that complaint to. You never know who an employee is going to name in a complaint. They might name the CEO of your company. They might name just the name of your company, or they might name, at least initially, their direct supervisor. And, OSHA or the EEOC might not know any more information than that. So we don't know who it's going to go to. In a lawsuit, typically it goes to your corporate agent or someone that's designated to accept service of process. With the EEOC, it might be different. So you should have some sort of policy where someone knows, and again, including supervisors all the way up, that if we receive some notification from the Department of Labor or the Equal Employment Opportunity Commission that complaint gets forwarded directly to, let's say, HR, which is where I would recommend that the complaint goes, or a similar, your company might be set up differently, but someone else in your company who's designated to handle these complaints. Then, let's say, it is the HR person. Then you have your team in place to investigate and begin the process for responding to the complaint. Whether that's your HR team, whether it's your health and safety team, whether it's, top management at the relevant facility. And again, speaking of the relevant facility, that also reminds me back to my first point. You might have different facilities at your organization, and the complaint just came to one maybe small facility that isn't used to having these types of complaints. So it's really important that it gets to the right person, because it's not great when you have to tell OSHA, tell the DOL or EOC, oh, sorry, we missed the deadline. We didn't even know that the complaint was filed. That sort of hurts your credibility to say, oh, we have great processes in place, but we actually didn't even have this process in place. So it just, really makes you start off on the wrong foot. And then the last kind of bullet point I have right here is take immediate steps to collect and preserve relevant documents related to the complaint. When thinking about it more, I might make that a little broader and just take immediate steps to figure out what to do to collect and preserve relevant documents. And that might be calling legal counsel if you have legal counsel. These are the types of complaints you typically do want to engage either internal counsel if you have, or outside counsel. And then with that counsel involved, you can then take steps to collect and preserve what documents might be relevant. And I'll talk a little bit more here on this page about what might be relevant. So, in collecting the relevant documents, you would want to review the complainant. We're talking about him or her. You'd want to review their personnel file. You'd want to review personnel policies and procedures relating to the subject matter of the retaliation charge. You'd certainly want to review any grievances made by the complainant. He might be called a complainant, he might be called a charging party. It depends on who's issuing the complaint. And you'd certainly want to review and collect all internal complaints and or disciplinary action that occurred with that employee. You would then begin, conducting your own investigation of the complaint. But let me say before that, let me just make sure I don't forget about this first bullet point. That's extremely important. Often the complaining worker is no longer employed. They've either been fired, they've resigned, they might claim retaliatory or constructive discharge, but oftentimes they're not employed. If they are employed, however, which does happen, you need to make sure that you take no actions to retaliate against this individual. It really is, we see it time and time again that an employer is upset about a claim that was filed and they're all concerned about that claim. And at the end of the day, they really didn't have much liability regarding that claim, but they ended up retaliating in some way, shape, or form against the individual who brought the claim, and then that is where they get penalized. I always provide analysis to football or basketball, where it's often not the person who pushes first, but then the referee might see the person who pushes in retaliation, and then that person gets penalized. So please make sure, that doesn't mean you have to treat this person any differently than you have to treat other people. You don't have to treat him or her better, but you also can't retaliate. Then when you're conducting your investigation of the claim, I mentioned the different documents you want to review. The first prong here about determining whether it's timely, that might be in conjunction with your legal counsel. Also in conjunction with your counsel, you may want to interview employees with knowledge of the claim, so you can really get a sense of what happened, and then record your investigation and findings. And then the final bullet point here is the preparing the position statement, which is a response, it's a letter in response to the charge of retaliation. And some employers do that on their own. I'm a little biased here as outside employment counsel, but I do recommend you do use employment counsel for that, because a position statement is really important. And if you don't have experience doing it, that could be the primary difference between prevailing on a claim or unfortunately not prevailing. Sometimes the facts are the facts, but the way that you present the facts are extremely important. And that's why the primary goal of a position statement is to present your facts in the most favorable light that you can. And that means giving context to the charging party's allegations from the employer's point of view, explaining your actions in the context of the relevant law. And really, it's as if you were standing in front of a jury. It's telling a story that is easy for the investigator in this case to follow. To explain that in further detail, some of the things you want to do is provide documentation, which could be exhibits that support your position in the position statement and refute the charging party's allegations. By providing a robust position statement, you want to demonstrate you are demonstrating that you take the allegations seriously, and you are also establishing trust with either the EEOC or Department of Labor. And the goal here is to persuade the agency to dismiss the complaint. The statement of facts is extremely important. It's really, a position statement is split up into the statement of facts and a legal analysis. And sometimes we assume the legal analysis is just, the main crux of it. And that is very important. But the statement of facts really not only introduces the key players involved and discusses, all the relevant issues, it should, if you do it right, almost be a legal argument. And all of the headings essentially should set forth all of the reasons why the adverse employment action happened that had nothing to do with the purported protected activity. You want someone to read the statement of facts and think that your actions were fully warranted and the charging party has no basis for his case even before they get to the legal analysis part. And then when you get to the legal analysis part, that should further take your facts and then combine the facts with the law to further lay out how the charging party has failed to meet his or her legal burden under the law. And some of the examples we say here is, perhaps the employee cannot show that he engaged in protected activity. Perhaps he cannot show a causal connection between his protected activity and the adverse action. And then, as Victoria talked about earlier, the important, at the end of the day, the most important thing, the law should show how the facts, the law should combine the facts to show that you as the employer have established a legitimate reason for the adverse employment action. And that is the reason for the termination, not any sort of, and that is not any sort of pretext for discrimination. You should provide documentation as much as you can. If the employee was written up, if he had disciplinary notices, if he had poor employment evaluations, you want to include those. You may often want to include affidavits from supervisors explaining why the disciplinary actions were taken. You do want to keep in mind that such documentation could be provided to the charging party, but I still think it's very important to provide all of those documents. And then, the charging party will have an opportunity to respond. You may or may not see that response. It really depends on what OSHA or the EEOC determines it is advisable. But the charging party likely will see your position statement. And then the last couple minutes here, just quick recommendations to avoid a whistleblower claim. You want to establish a complaint policy or policies and disseminate those policies to the employees. Perhaps it's in your employee handbook, or it might be standalone policies that make sure employees know how to complain. The last thing you want is to be in front of the EEOC and have the employee say, well, I wanted to complain, but I didn't know how. The policy should be written in clear, simple language, so it's easy to understand. And you want to clarify what behaviors and issues should be reported, how the complaint should be made, and what will happen next in the investigation process. You want to make sure that the investigation follow-ups will be prompt, and then you actually want to do so promptly. You don't want to have a policy that says one thing and then not, and then do something different. And as I said earlier, you want to ensure you have a policy that says that an employee will not be retaliated against for reporting or participating in an investigation. Employees should be complained on this complaint procedure, both your higher level and lower level employees. Supervisors and managers must know not to retaliate against employees. And specifically, management should receive instruction on A, how to respond to complaints, B, the types of actions that are likely to be considered adverse, as we've discussed, the perception of retaliation. I think Victoria discussed, that you want it to be, you don't want to take an adverse action a day after someone engaged in protected activity. You want to effectively communicate your legitimate but adverse employment actions, and you want to document legitimate responses to employee conduct. And here in the last slide or two I have, you want to develop and maintain documentation, both prior to and at the time of the adverse action. It's very good to be able to show the EEOC or the DOL that you have clear written documentation showing the decision-making process for the adverse action made in accordance with company policies and procedures. Similarly, if you interview employees, you want to keep notes, you want to provide written certifications, and you want to provide written documents of your actions. And finally, the last slide here is be consistent. And you see this little cartoon we have provided. It is the best defense when you can when you can show the fact finder that another employee, it's called a similar situated employee, other than the complainant, who did not complain or engage in protected activity, was also treated in the same manner. If he's being fired for being late, you want to show that other people who were late were also fired, not just the individual that complained about some sort of safety or other issue.
And then just, I think, before we jump into some of the questions too, we do have some webinars coming up in our series, both our labor and employment series, which you can see here, as well as our OSHA series. And then another great resource that we provide on our website are our various blogs. So definitely check those out as well. And we do have some time here for a couple questions. If we don't get to your question today, we'll certainly try to go through and see if there's any to follow up on. And additionally, the slide that you all have should also have our contact information, as you can see here as well. And you can certainly feel free to call or email us as helpful. So with the time we have, we'll do a couple more questions. And let's see. Okay, from a legal standpoint, should we encourage employees to file complaints internally before considering taking the OSHA route? Yeah, I mean, I think Jordan talked about this, in the slides immediately previous to this, sort of what we recommend is how to encourage employees to make complaints internally. We certainly, it's certainly the better circumstance from our perspective, from a legal and liability perspective for complaints to be handled internally. Once the agency gets involved, we have a little bit less control over the process. There can definitely be some say from the agency as to their expectations for how certain things can be handled. And so we definitely would promote setting up systems and policies to ensure that employees are encouraged to report complaints internally. And in doing so, making sure that they, again, like Jordan referenced, are trained on any complaint policy that's in place and who they should go to, and what the options are and what they can expect as far as an investigation of complaints they're filed. So employees have a really good understanding of how that process works. And then from the employer end, making sure that that process is implemented as established by those policies and procedures, as well as by the training.
I would just say real quickly, though, I think you would want to encourage the employee that we would like to do everything in our power to, make sure we fully address your concern. But I don't think you want to, you asked the question from a legal standpoint. I don't think you want to discourage them from, filing a complaint with OSHA. What you could say is, we would hope you'd be satisfied with our response and there's no need. But if you, determine there's a need to take the complaint to OSHA, you are free to do so. We don't want to look like we are preventing them or threatening some sort of, we don't want them to even think we're threatening adverse action if they file a complaint with OSHA, because that could then be the retaliation as opposed to whatever they're already thinking about.
Another question we see is there a statute of limitations for OSHA to initiate litigation under Section 11C? And that is a great question. There's the statute of limitations that Victoria reviewed as far as, the time frame in which an employee has to file a complaint. And that is 30 days, which, compared to a lot of other statutes is pretty quick. But once OSHA has the file and once they initiate their 11C investigation, the answer is, in practice, no. I believe the statute says that an investigation should be completed within 90 days of the complaint being filed, but I can tell you from experience that never happens. I've never had one 11C case that has come to a conclusion within 90 days. And it's certainly not something that's enforced. And so, I think unfortunately with the 11C cases, and then for those of you that have been involved with them or with EEOC investigations, they can take a very long period of time, for that process to continue. And, with 11C, there's no sort of point at which the employee can pull their complaint and go ahead and file a lawsuit or anything like that. So, the investigation really continues until there is, a finding one way or the other as to whether there's merit in the complaint, or if the employee decides on their own to withdraw the complaint for some reason. Oh, and I see Victoria. Victoria answered that in a much more summary manner than I did. It looks like there was some discussion around sort of providing training in training and policies in a language that employees understand. That's definitely a best practice to the extent that it's possible. If you have, a large portion of your employee population that is Spanish speaking, for instance, it is definitely, helpful to be able to provide policies in a language that employees understand and training in a language that employees understand, particularly from the perspective of, if there is some litigation that occurs or a complaint is filed with the agency and there's an investigation, there's definitely a stronger position of the employer where they can show that, there was a policy in place that addressed this concern, or there was training that was done to address this safety concern, and there's no reason that the employee, wouldn't have known of it or understood it because, was provided in a language that they understood. All right, so I think that that's pretty much it. If we, like I said, we'll go through again and see if there's any questions that we missed and follow up with those that asked them. But again, if there are any remaining questions on this topic or any others, certainly feel free to reach out to any of us with those questions. And then certainly, you all have access to our blogs and webinars, so hopefully those can be a helpful resource as well. And thank you everyone for joining today.
Thank you.